So first of all, thank you for LUMS for hosting this important conversation on water and climate change, one of the most pressing issues that is facing the country today. I'm not going to go into the depressing facts that Dr. Ali Khan familiarized all of us with yesterday. I think they've left their lasting impact. But in all of this second session titled Water and Climate Litigation and Governance, what this session will attempt to do is familiarize us with what are the current legislations in field addressing the issues of environment, climate change, water resource management, and looking at it from a holistic view. So what is currently happening is that water issues, whether they're related to groundwater depletion or quality, whether they're related to canal irrigation, water management, or whether they are the sacred water in a temple in Katas Raj. All of these issues, unfortunately, have to be resolved within the formal legal system, which means that the current laws that are applicable come into play. It means that the current institutions come into play. It means things like the 18th Amendment to the Constitution come into question in all of this. And there's this whole political debate surrounding what allowances should be there or not, and there is a pressing need for some cooperation in this whole scheme of things in order to be more equitable in how we deal with water, both for the current generations and the future generations to come. So I won't take any more time. Our first speaker for the day is Zehra Zaidi. She is a visiting assistant professor at the Sheikh Ahmed Hassan School of Law here at LUMS, and she brings with her not just an academic background but a holistic view of the legal regimes as well, since she's been practicing law in Karachi and London, and specializes in company, commercial, environmental, aviation, and shipping law. With over a decade of teaching experience, she has taught diverse legal subjects, including contracts, torts, and public international law. Her research focuses on compensation claims for pollution arising from oil spills in the global south. She holds a BA LLB from the University of London's International Degree Programme and was called to the bar at Lincoln's in UK. So Zehra, if you could please come and present your paper, Navigating Pakistan's Environmental Laws, the Untold Story of Tasman Spirit Oil Spill.
Good afternoon, everyone. I think it's probably afternoon by now. My presentation today is in fact a case study of one of Pakistan's worst marine pollution disasters, an oil spill dating back to 2003. And this resulted in extensive pollution of Pakistan's coastal waters, for which no compensation has been paid or received to date. Now, this is a part of my broader research on oil spills, marine pollution, and access to compensatory regimes by developing countries. Now, today I will begin by looking at the background of the incident, the shortcomings within our environmental laws. Now, Pakistan is a coastal state. We have 3 international ports, and the likelihood of such a disaster recurring cannot be ruled out. And so I will also suggest areas of reform and steps Pakistan can take to protect itself, its vulnerable communities, and coastal waters for marine pollution going forward. So, in July 2003, the Tasman Spirit, an oil tanker carrying approximately 67,500 tons of Iranian crude oil bound for the Karachi harbour, became grounded as it was entering the port. And in the process, it developed cracks along its base. And on the evening of August 13, a few hours before the country's Independence Day, the tanker split into 2 and began to disgorge large amounts of oil into the harbour. About nearly 38,000 tons of crude oil were spilt into the Arabian Sea. To give you some context, that's about more than 100,000 barrels of oil that we're talking about here. Now, the Tasman Spirit was owned by a Greek company, registered and insured by an American insurance company, which is a part of a group of protection and indemnity marine insurance clubs, a small group of 5 all over the world, which between them insure all tankers, ships, and many other vessels. It had been built in Japan with high tensile steel, but it had what we call a single hull, which meant that it was more susceptible to damage and spillage in the case of the accident. I'll tell you a little bit more about the background before I get into the legal aspect of the incident, but the tanker's grounding was due to a combination of factors, including human error and bad weather. The ship was, or the oil tanker was scheduled to berth in Karachi's harbour channel, but this was delayed due to the Pakistan Navy officials requesting that a submarine be berthed instead. Now, the Karachi port schedules berthing according to high tide, and high tide was crucial for the Tasman Spirit because she was a deep loaded vessel with so much oil on it. But because of the intervention, the original plan was disrupted, and the vessel was brought into the harbour, moored in when the tide was low, and this was insufficient depth for berthing. Now this, along with incorrect navigational directions which were given by the pilot at Karachi port, led to the tanker being grounded. So when we look at the impact of the Tasman Spirit oil spill, the coastal environment that the Tasman Spirit occurred in is a rich, diverse, tropical marine ecosystem with extensive endangered mangrove forests and hundreds of species of fish and crustaceans, many of whom are very important to commercial fisheries and, of course, also important to the marine food web. Now, baseline data on the nature of the extent of pollution in the marine ecosystem prior to the Tasman Spirit was scarce, and this scarcity has made it challenging to fully assess the oil spill's full environmental impact. But the significance of the incident as a major pollution incident in Pakistan remains undiminished. And what this also does is it highlights to us the broader issue of limited environmental information and disclosure in developing countries such as Pakistan, in contrast to sort of developing nations such as the United Kingdom and the United States, where information is readily available. So for example, when we look at oil spills such as the Exxon Valdez, the Sea Empress, the 2010 Deepwater Horizon BP oil spill, there is extensive information available on the extent of the environmental damage, and studies are still being conducted today, till today, I mean, 30, 40 years after Exxon Valdez. Whereas when it came to the Pakistan and Tasman Spirit, after the first couple of years, there were really no continuing studies that were done. In terms of the health impact, of course, the immediate impact was to residents, and the residents included the residents of sort of upper class neighborhoods of Karachi, such as Clifton and DHA, but also low-income neighborhoods such as Shirin Jinnah Colony and others were also affected and exposed to toxic vapors for several months. And this led to various health impacts, nausea, asthma, breathing ailments. But perhaps the worst affected were the 300,000 fisher folk residing in the affected coastal areas who are already impoverished, marginalized communities of Pakistan. Surveys from the Pakistan Fishermen Folk Forum showed that 13 coastal villages comprising of a population of 200,000 were directly affected by this oil spill. In the immediate aftermath, the government imposed a 6-month fishing ban, and the market prices for fish declined by 60 to 70%. Exports completely stopped. There was also loss of revenue to the small businesses and local vendors who make a living by the coastal beaches of Clifton, Hawke's Bay, etc. in Karachi. And the cost to the city, nobody knows. It remains uncalculated to date. Now, over here, we have the primary international conventions applicable to oil spill pollution compensation, and they are based on the environmental principle, the polluter pays principle. When we look at these, treaties, the necessity for them arose in 1967 with the Torrey Canyon oil spill, tanker oil spill, which happened off the coasts of UK and France. And the governments had immense difficulty recovering the costs that were incurred as a result of pollution damage in their local courts. So as a result of that, the international community, the various stakeholders, ship owners, cargo interests, governments, they got together with one of the UN's agencies, the International Maritime Organization, and compensation schemes were created to ensure that coastal states were sufficiently compensated for marine pollution. Now, there's many treaties in there. I won't go through all of them, but what is relevant to us for the purpose of the Tasman Spirit is the Civil Liability Convention, which I'll refer to now as the CLC of 1992, and the Fund Convention. Now, these are really important treaties because what they do is they establish strict liability for ship owners. So what that really means is, for any laypersons in this room, that the country that has suffered the oil spill will not have to show that the ship owner is at any fault. And what they do is, these regimes, they create tiered compensation structures for affected parties. And they introduce these international funds which act as additional sources of compensation. Now, and these funds, they are financed, interestingly, not by governments, but by the receivers of oil in state parties. And what they do is they allow for uniform application of liability within state parties. And this leads to clear understanding and predictability of financial risks that are associated within shipping. And for a claimant, a claim of reimbursement as a result of oil pollution can be made under the relevant convention, and they can approach the ship owner or the insurance company directly, so long as they can prove their losses without having to go to courts, without having to even engage lawyers. However, there are certain limitations where there's a time limit of 3 years within which claims can be brought. Now, what happens with the CLC 1992 is that ship owners can limit their liability upon the gross tonnage of their tanker. And in situations where the compensation available under the CLC is not enough, there is additional money that is available under the 1992 fund. And after 2003, there have been further protocols for the establishment of other funds. And today, total compensation payable now exceeds $1 billion US. Now, at the time of the Tasman Spirit incident, notable non-signatories to the CLC included the USA, Iran, and Pakistan. So Pakistan was lacking the protections that were provided by this convention, and so any litigants had to seeking compensation had to rely on Pakistan's national laws. And what that essentially meant is that they had to prove negligence, damage, legal title to the ocean. And this sort of complicated compensation efforts. And our government faced the same challenge that the UK and French governments had faced 30 years ago, which had led to the creation of these regimes. Because the government, as well as other claimants, the fishermen folk, the DHA, the local vendors, there were many cases that were filed in the local courts. They all had to prove negligence, damage, and ownership. And questions such as, who has title to the ocean? Who is responsible for this claim? Sources of compensation funds. The law is complicated. I mean, the law may allow, Pakistani law does technically allow unlimited claims. But the problem was that given the evidence of fault on part of the port authorities, suing the ship owners became extremely difficult. Now, had Pakistan been signatory to the CLC, there would have been no question of fault because, like I said, the CLC operates on the principle of strict liability. Now, in order to get financial guarantees and exert international pressure, the government held the 8 crew members of the Tasman Spirit. Not only that, they also imprisoned the master of the salvage vessel that came in to carry out the salvage operation of the Tasman Spirit. And this group became known in the marine world as the Karachi 8. So you've heard of the Birmingham 6 and the Guildford 4. We had our very own Karachi 8. Now, the detention of these individuals, especially the poor salvage master of the salvage vessel, shocked the international maritime community. They were sort of housed in prison. I mean, they were put up in a hotel, but they were not allowed to leave. But this detention lasted for 9 months, and there were incidents of some of the crew members even trying to take their lives because they were, of course, extremely worried about what would happen to them. But this led to considerable pressure from international bodies such as the European Union, the International Maritime Organization, as well as the Greek government, because as you may remember, I had said earlier that the Tasman Spirit was registered in Greece. And this led to a diplomatic and economic standoff. Now, leaked statements showed that the Pakistani government was seeking compensation in the area of $5.7 billion, which was the largest insurance claim ever made to the marine insurance market. Ultimately, 9 months later, the Karachi 8 were released under international pressure. Apparently, Colin Powell had to have a word with General Musharraf, and there were various threatened economic consequences and the jobs of thousands of Pakistani seafarers who work in EU and Greek merchant shipping was threatened. Now, let's take a look at Pakistan's own national and international regulatory framework relevant to maritime incidents. We can start with our constitution, which forms the foundation of our legal framework, and it includes protections for fundamental rights. However, the constitution does not contain statements of principle or policy relating to the environment. And this takes us to the Sheila Zia against Wabda case of 1994, which heralded a new era for environmental law in Pakistan, where for the first time, the Supreme Court of Pakistan recognized that the right to a clean and healthy environment was a part of the fundamental right to life, which was guaranteed by the Constitution. The Constitution did list environmental protection and ecology as subjects that could concurrently be legislated upon by Parliament and provincial assemblies, and this had led to the creation of the Pakistan Environment Protection Act of 1997, which was at the time the most significant environmental legislation. It was applicable to marine pollution, but the coverage was inadequate. Today, now, after devolution of powers under the 18th Amendment to the Constitution, environmental pollution now is a provincial subject, and the provinces have their own environmental protection acts. But going back to the time, we had a national conservation strategy which addressed other forms of pollution, such as air and fresh water pollution, but again, oil spill water pollution was not specifically included. In the wake of the Tasman Spirit disaster, Pakistan did formulate the National Environmental Policy. This was our first major policy initiative which addressed oil spill management and spoke about the creation of a national oil spill cleanup plan. But this was in 2005. as you can see, at the time, none of the major environmental legislations and policies sufficiently addressed marine oil pollution at the time, and they still remain inadequate today. Beyond this, there was other regulatory framework that we had. So, for example, there was the Merchant Shipping Ordinance of 2001, the Maritime Security Agency Act of 1994, the Karachi Port Trust Act of 1994. But the issue with these laws were that they assigned different agencies the responsibility to implement a pollution control. They did not specifically designate one agency as the lead agency. And so the domestic regulatory framework was characterized by fragmented laws and dispersed responsibilities. And also their existing penalties to the polluter was extremely low. And these shortcomings are apparent if you see these pictures. These are some of the pictures from the cleanup operations. The issue of jurisdiction complicated the cleanup operation because there was 3 agencies trying to carry out the cleanup. There was the Karachi Port Trust, the DHA, as well as the city government. No one seemed, no one appeared as the lead agency, lacking a clear management. Of course, hundreds of workers were involved, but they did not have enough protective gear, including gloves and shoes that could be made available to everyone. And when it comes to oil pollution, one of the most important needs is for there to be storage where there could be temporary storage of the oiled waste that is cleaned up, and there was no place for storage either. And all of this lacked because we did not have one single coherent oil spill management policy. Now, this was the local regulatory framework. When you look at the international framework, Pakistan was a signatory to the International Convention for the Prevention of Pollution from Ships, which is commonly known as MARPOL. Now, so we had our Pakistan Maritime Security Ordinance of 2001, which gave effect to MARPOL. But MARPOL didn't really help in this given situation because it aims to minimize accidental pollution by improving ship design, construction, and operation standards. Whereas most spills result from navigational errors and structural inadequacy and poor maintenance. So yes, in certain areas, MARPOL has been successful, but the effectiveness of MARPOL is limited by the fact that there is no international body or authority that can enforce the convention that can enforce the convention. Now, in contrast to MARPOL, when you see the CLs, and Pakistan had also signed the International Convention on Oil Pollution Preparedness, but not been ratified into our law, and so it was not applicable in the given situation. Now, when you see these treaties and you contrast them to the CLC 92 and the FUN 92, these treaties were formed to focus on liability and compensation, whereas MARPOL, etc., were not. And the proponents of these international regimes have argued that they allow for prompt and equitable compensation to be given to third parties. And like I said earlier, where a country has signed the convention, the country and the claimants are saved from costly, time-consuming litigation. In addition, what's important is that these conventions can be extremely important for developing countries because the funds are not financed by governments. The funds from which payments are made are financed by contributions from the receivers of oils in member states. Now, as most developing countries do not receive oil in such large quantities as compared to the developed world, the conventions allow us to receive protection at a low cost, while the expense of major spills is covered mainly by oil companies in industrialized countries. So what needs to be done? No doubt, initially, the Tasman Spirit acted as a catalyst for regulatory change in Pakistan. And initially, it did succeed in bringing environmental issues to the forefront of the government's agenda. And even after the oil spill, the government did ratify the Civil Liability Convention of '92. However, they did not seek compensation under it because they wanted more than what was being offered. Unfortunately, that has to date not come. There were other changes as well, like I mentioned, the National Environmental Policy, but the changes progressed slowly and remained insufficient. So the incident has exposed significant lapses of implementation of conventions, and most importantly, there is a lapse and there is a requirement of one operational national oil spill contingency plan. And also Pakistan lacks the logistical support, etc., that is necessary for carrying out oil spill cleanup operations. Now, to improve oil spill management, what we need to align our domestic regulatory framework with international regimes. And that will require ratification of the key International Maritime Organization sponsored conventions, and most importantly, the Fund 1992. Subsequently, we need a single piece of legislation to be enacted to fulfill Pakistan's entire obligations, international obligations under MARPOL, CLC 92, and the Fund 92. And additionally, regulations relating to oil spill planning and reporting requirements need to be consolidated and streamlined within Pakistani law with one competent authority overseeing these efforts. Thank you very much.
I'd now like to call Mr. Ahmad Rafay Alam, who is one of the leading environmental lawyers and activists in Pakistan. Mr. Alam regularly advises the federal and provincial governments and provides corporate clients strategic sustainable insights. He also serves as a member of the Pakistan Climate Change Council, the Punjab Environmental Protection Council, the Hisar Foundation's think tank on the rational use of water, and is an advisor to Air Quality Asia. He will be presenting water laws in Pakistan, dispute resolution and federalism.
Bismillahirrahmanirrahim. Assalamu alaikum, everyone. It's an absolute privilege to be able to speak at this conference, and I want to thank LUMS University and Yale University and all the people involved in putting a fantastic schedule together on a subject that's very close, especially to my heart. I'm going to speak a little bit about Pakistani law today and the Pakistani constitution. I want to sort of give a historical backdrop of how water disputes played out in pre-partition India, and then compare them to how our own constitution developed its dispute resolution mechanisms, and how we have in practice conducted dispute resolutions. And in doing so, trying to point out some of the legal principles that were missing and the opportunities of our provinces acting in a true federal spirit from moving. Let's start, well, let me start with this actually. I love this map. This is a 3D map of South Asia. And it sort of explains in some ways what we're doing here as well. As you know, many hundreds of millions of years ago, a large chunk of rock broke off from Africa because of continental drift, and over the course of hundreds of millions of years, collided into Asia. So that triangle you see, the sort of characteristic identification of India, is actually a result of continental shift. And the continents colliding created the Hindu Kush, Himalayan, and Karakoram mountain ranges, the sort of two continents coming together, forming this, what I can consider a massive wall of sorts, some of the highest mountains in the world. And so, as the Earth tilts, and this part of the world gets a little bit closer to the sun, temperatures on the landmass rise and hot air goes up. And as hot air goes up, cold, moist air from the ocean, from the Arabian Sea, from the Bay of Bengal is pushed inland around about a few weeks after the hot season starts. So hot season starts late April, early May, and then this wind carrying moisture puts all of this rain onto South Asia, the monsoon. And whatever isn't deposited in the form of rain over the landmass collides with this wall of mountain and eventually becomes the snow that we have seen over the course of hundreds of thousands and millions of years. And the next summer, that snow melts, and as it melted, it's created these troughs. You see the Indus Delta over here, the Indus Basin and the Indo-Gangetic Basin. This is basically water escaping or ice escaping from this wall of water. And it creates these troughs, and this is where we live. These troughs also between the mountains and the Deccan Plateau over here, this trough is also during the winter seasons when hot air isn't rising, one of the reasons why this part of the world is so susceptible to air pollution. If you see any satellite image of North India during the winter times, you'll see from Kabul to Calcutta a huge pall of smoke over here, and that just has to do with the geography that we're in as well. So this map is fantastic. It explains quite a lot. But let me start my discussion with the management and governance of water in pre-partition India. India has, well, we're familiar in Pakistan with just one basin, but there are several water basins in India, and they traverse many states, and at that point, before partition, many princely states as well. Now, there were forms of government for India in the 19th century, but in the early 20th century, we start seeing some reform with the Government of India Act 1919. And one of the important things that the Government of India Act does is it sets out the responsibilities of the central government in Delhi, called the Central List, and it sets out the responsibility of governance for the provinces, called the Provincial List or the State List. And then there were a list of concurrent subjects where the center and the states could also make laws and exercise executive authority. Water, that is the natural supplies of water, water irrigation infrastructure and such like, was defined as a state subject in the Governorian states before dividing how the water would be shared. And is an example also of cooperation on water in India that goes back to the early parts of the 20th century. Things changed with the Government of India Act 1935 when a specific adjudication forum was provided for interstate disputes between water. So now if two states had a dispute over the natural flows of water or the diversions of water that would impact their resources, they could go to the Governor General in council, as it were. And the Governor General had the power, if unable to make a decision there himself, to form a committee that would look into this dispute referred to him and propose solutions. With this forum in place and with irrigation infrastructure planned, I think it was the Bhakra Dam and others on again the Sutlej and the Ravi, concerns were raised by Sindh under the Government of India Act in the late 1930s that the execution of waterworks in Punjab would impact water resources in Sindh. And so the matter was referred to the Governor General in council, who nominated excuse me, a Bengali judge, B.N. Rao, a jurist, to lead a commission into looking into how to adjudicate this dispute. The Rao Commission sat for a couple of years and published its report in 1942. It's available online. It is a remarkable example of legal scholarship and also just very good English. Justice Rao subsequently became, who was nominated to become a judge in the International Court of Justice, really led a stellar judicial career, and this was an example of his ability to be able to absorb all of this information about irrigation and water law around the world and give a concise statement actually of what water law or modern water law in the world looked like in 1942. And in doing so, he set out the principles upon which he believed water disputes in India would be adjudicated upon. Very importantly, he ruled out these ideas of what's called the doctrine of sovereignty and riparian doctrines of water. The doctrine of sovereignty is relatively straightforward. It's sometimes called the Harman doctrine. It's the notion that if a state owns water, it owns it absolutely to the exclusion of everyone else. This is not even a legal principle, it's just an idea. Then you have riparian law, which is actually an offshoot of Roman law, which goes back thousands of years and has more to do with the ownership of land and what you own above and below it than really the principles of sharing water. And Justice Rao felt that sovereignty principles and this riparian doctrines were not suited for India. Instead, he pushed for and recognized this idea of equitable apportionment as the basis of water division in transboundary water disputes. I should point out that equitable apportionment was also very much what modern international transboundary law was in the early 1940s. And transboundary water law has moved on since and added to the idea of equitable apportionment. For example, now modern water law also looks at conjunctive use. So you're not just looking at the surface waters, you're looking at how they're connected with groundwaters and aquifers, and legal principles of sharing are based on this better idea of how water, surface water and groundwater work together. But as far as 1942 is concerned, equitable apportionment is very much very modern, cutting-edge legal theory, and this is what Justice Rao says should apply in Pakistan. Unfortunately, partition took place before India and Pakistan, before Sindh and Punjab could work out the financial details of the Rao Commission report recommendations. And partition put a line in the irrigation infrastructure between India and Pakistan and created a riparian relationship where none existed before as such. And sort of the Rao Commission report and its recommendations couldn't really be applied after that because the system had changed. The very physical nature of the water system had changed. So now we come into Pakistan. Pakistan inherits, this is a schematic map, I should have pointed out over here, that this is a map of the canal irrigation infrastructure in what is now Pakistan that was left by the British by the time of 1947. The partition line, when it was drawn, impacted only one or two canal systems on the Pakistani Punjab side. That's the Upper Bari Doab Canal, which was majorly impacted. But all the other canal systems over here were unaffected by partition and the partition line. So this idea that partition drew a line between the largest contiguous irrigation, sort of gravity flow irrigation system in the world is true, but not entirely correct because it only impacted one or two canal systems. Right? So it wasn't this huge big shift in the system, but it did create a riparian relationship with none existed. As we all know, after the 6-month standby agreement in April 1948, India turned the headworks of the Upper Bari Doab Canal off, leading to a series of events which eventually culminated in the Indus Water Treaty of 1960. Now, the Indus Treaty of 1960 is very interesting because unlike the Rao Commission report, which seeks to divide water on the basis of equitable apportionment, the Indus Water Treaty divides the 6 rivers of the Indus Basin. So the 3 eastern rivers, the Beas, Ravi and the Sutlej, and their waters now belong to India, and the 3 western rivers, the Indus, the Chenab and the Jhelum, and their waters are to be, they're supposed to flow into Pakistan. And I should point out that the Indus Treaty is the only transboundary water arrangement in the world that divides water and doesn't share water. So the legal basis upon which the Indus Treaty actually works isn't following the principles of the Rao Commission report. It's a very technical document. It seeks to find an engineering solution to water sharing, which in some ways the Rao Commission says is a political form of art to be able to delve into what people need and what their resources are, and so on. Now, over here, the schematic better explains the partition line over here between India and Pakistan. These are the 3 western rivers. These are the 3, these are the 3 eastern rivers, and these are the 3 western rivers. With the 3 eastern rivers' waters being used by India, the Indus Water Treaty also included the construction of an Indus Basin development works, which were the Terbela, Mangla and Kalabagh Dam, and a bunch of these link canals which brought water from the western rivers to the eastern rivers through a system of interbasin transfer. So while the eastern river water is being given to India, there are now diversions from the Indus to those eastern rivers to replenish their flows. I should point out, and this is very important in understanding whose responsibility water governance is, that the 1 unit was declared in Pakistan in 1954. And the 1 unit dissolved the 4 provinces and created the province of West Pakistan, and also dissolved the 4 irrigation departments that also existed. The Sindh irrigation department did not exist at the time. And as far as Sindh is concerned, during the time of 1 unit, one of the objections that they had to the Indus Treaty was that the Indus River which is where Sindh gets its name from, belonged to Sindh. As Dr. Hassan Karar was talking about, the people of Gilgit-Baltistan say the water is theirs. Here we have Sindhis, lower riparians, saying this water is ours, and accusing the Punjab and Punjabi generals of diverting the water of the Indus into Punjabi rivers, having given those Punjabi rivers to India. So there's an internal conflict and a Sindhi apprehension in the Indus Water Treaty that this water belonged to us, the water of the Indus belonged to us, but is being diverted to the eastern rivers under the Indus Water Treaty without our representation. And this happened because of the 1 unit period of time. Now, the 1 unit period of time is also when the West Pakistan Water and Power Development Authority was established. This was the authority that would carry out the Indus Basin development works. Please notice the West Pakistan Water and Power Development Authority, because water was a provincial subject even then. And so as a provincial legislation, WAPDA was created. There was an East Pakistan Water and Power Development Authority as well. It was only until 1973 when, 1971-72, when 1 unit was disbanded and the provinces formed again, that you got the provincial irrigation departments back, you got provincial agency back, but now you had a water manager for a provincial subject that controlled spatially the entire sort of geography of Pakistan. So we had set up a provincial entity for water, which subsequently de facto became a federal entity for water. And I think there's a lot of misapprehension in Pakistan about who controls water, that it's Islamabad. I think this is more of a historical accident coming out of the creation of WAPDA and the 1 unit and the irrigation infrastructure that was developed since. But water always has been a provincial subject. And it was shortly after the abolishment of the 1 unit and with the 1973 constitution that I want to come to just over here. Under the 1973 constitution of Pakistan, there is a forum for inter-provincial water disputes. And this forum is the Council of Common Interests. The Council of Common Interests is a constitutional body forming the Prime Minister, the 4 chief ministers, some federal ministers, and they are responsible for formulating policy on a certain number of federal subjects, what is called Part 2 of the Federal Legislative List. So we get the provinces and the chief executives of the provinces along with the chief executive of the federation to sit together to formulate policy on a number of essentially inter-provincial subjects, but formulate policy only. Water is not on the Part 2 of the Federal Legislative List. WAPDA is. So the Council of Common Interest can set policy for WAPDA, but not for water, because water is a provincial subject. That being the primary responsibility of the Council of Common Interest, it's also the forum, and just like the Government of India Act 1935, where inter-provincial water disputes can be referred. So if I can quote from here, my eyesight is going, I don't know, certainly no one in the back can read this. If the interests of a province, the federal capital, or a federally administered tribal area thereof to water from any natural source of supply have been or is likely to be prejudiced by any executive act, the failure of any authority to exercise its powers, the federal government or the provincial government concerned may make a writing to the council. So you approach the Council of Common Interest. It has to be a province or the Islamabad Capital Territory. The federally administered tribal areas have now been absorbed, so they don't exist anymore. Which brings up a very interesting point about Gilgit-Baltistan. It's not mentioned here. Gilgit-Baltistan is not a province. It cannot file a complaint to the Council of Common Interests. So there's a slightly different story altogether. But this is the forum that we have to refer complaints to the Council of Common Interest. Now, this forum was first approached in 1976 when Sindh filed a complaint against Punjab and asked for an arrangement for sharing waters in the Indus system. The Council of Common Interests referred the matter to what's called the Chief Justices Committee. It was the Chief Justice of Pakistan and the 4 Chief Justices of the provinces in 1977, and they were given something like 120 days to come up with a solution. But before they could do though, the 5th of July 1977 took place and martial law was declared and the constitution was abrogated. And so our second attempt to have an inter-provincial water dispute adjudicated and finalized, just like the Rao Commission was thwarted by the partition line, this Chief Justices Committee and its adjudication was thwarted by the abrogation of the constitution. And the constitution didn't come back until 1988, and since then there has been only one further complaint to the Council of Common Interests, and that was in 2019 by Sindh, complaining that IRSA wasn't working well enough. And I'll come to IRSA in just a second. But in the history of Pakistan, while we have rich jurisprudence on how equitable apportionment should be the basis for interprovincial water disputes, we have never fully exercised the forum of adjudication and allowed a jurisprudence of water sharing to evolve in Pakistan. Instead, as a practice, we have imposed not just the Indus Treaty, but the Water Apportionment Accord, which aren't divisions of waters, they're allocations. They're not sharing water, they're dividing them. Let me come now and conclude with the Water Apportionment Accord and IRSA, which is now how in Pakistan we are dividing waters between the provinces. The Water Apportionment Accord was signed in March 1991. I just want to read off a couple of, I have the first and last page here that I want to show you. It's almost like evidence. I'm trying to build a case over here. It says here, as a follow-up to the meeting of the chief ministers in Lahore in March 1991, a meeting of representatives of the 4 provinces was held in Lahore on the 4th of March 1991. Another meeting was held in Karachi on March 16. A list of participants is attached. This is the back page. We have the chief ministers of the provinces, we have the irrigation and finance ministers all signing off over here. Just remember those names and titles for just a second. Now here comes the chunk or the meat of IRSA, where Punjab, Sindh, well at that point NWFP and Balochistan were to get a certain amount of water during the Kharif and Rabi seasons. Those are the 2 planting seasons, the farming seasons that we have, leading to a total of 114 million acre feet to be divided between the 4 provinces. So the Indus Water Apportionment Accord seeks to divide 114 million acre feet of water between the 4 provinces. The problem is that at the time the Water Apportionment Accord was signed, Pakistan didn't have 114 million acre feet of water. It had something close to 104 million acre feet of water. We have less now. Last year it was about 94 million acre feet. The difference between 104 and 114 million acre feet was the storage capacity of the Kalabagh Dam. This was a political document to get the provinces to agree on the construction of the Kalabagh Dam, because when it would have happened, why was Kalabagh not being built? Because Kalabagh was on the Indus. And when one unit was dissolved, Sindh got its agency back and always objected to another dam being built on the Indus, which is where the objection to Kalabagh came from. This is a political document that seeks to overcome that problem by promising Sindh so much water if Kalabagh is built. But it's a contingent contract, as we say in law. You have to reach this level of surface water availability before it can be effective. So until that happens, IRSA operates after section 14B over here, which it's engineering, but let me see if I can explain. The record of actual average system uses for the period 1977 to 1982 would form a guideline for the development of future regulation patterns. These 10 daily uses would be adjusted pro rata to correspond to the indicated seasonal allocations of the different canal systems. 1977 is when Tarbela became active and Pakistan got its water storage capacity. And so what 14B is saying is that we will take the averages of every 10 days, the average water flows in Pakistan every 10 days between 1977 and 1982 as the basis of predicting how much water is going to be in the system in the future and how we are going to divide water between India and Pakistan. This is not equitable apportionment, right? This is just a system of saying that based on previous averages, this is how we will continue to share until the 114 million acre feet becomes available, and then the water apportionment can happen, okay? But as my friend Dr. Danish Mustafa says, these type of averages, in the time of climate change, averages are useless. They're useless. Water flows are too variable. So not just that, if you look at, and my friend Fahad is very familiar with this, if you look at the Constitution of Pakistan, it says any contract made or in the exercise of any executive authority of either the federation or the province shall be expressly made in the name of the president or, as the case may be, the governor of that province. I read out the signatories of the Water Apportionment Accord. It's the chief ministers. So it can hardly be even said to be an agreement. It's a contingent agreement at best. probably doesn't have the constitutional authority to form an agreement, but it is this water apportionment accord that was put before the Council of Common Interests in March 1991, which was adopted by the Council of Common Interests. Now, again, the Council of Common Interests does not look at water policy. Water is a provincial subject. It only looks at water disputes. The Water Apportionment Accord is not a dispute referred to it by a province of the Islamabad Capital Territory. And so I would argue that it was a legal overreach, a jurisdictional overreach of the Council of Common Interest to adopt this. But like I said, this was a political document to get Sindh to agree to the Kala Bagh Dam. It wasn't a legal document as such. And so what we have in Pakistan now is a system of water allocations that are not based on equitable apportionment. They are based on division and on averages. This is no longer sustainable in the time of climate change, and in fact derogates from the federalism that would be encouraged if provinces sat down and resolved their disputes in the manner provided in the Constitution. I'm a lawyer. I believe dispute resolution reduces pressure. It reduces pressure and creates a base of knowledge, a jurisprudence on how future disputes can be resolved. It clarifies things and reduces pressure, and we are depriving ourselves, as it were, of the benefits of this federalism by continuing to divide water amongst ourselves. Thank you.
Now I want to move on to Dr. Seemi Waheed, and I really want to hear her insights into all of this. She's someone whose research I've historically relied upon. I do a lot of public interest litigation, and in order to do so, you need some primary data that you can anchor yourself to in order to, formulate a legal argument around. And Dr. Seemi Waheed is someone who works in water governance and policy, and for the past 8 years has dedicated herself to covering issues of water usage, water management, especially within rural and metropolitan situations. From an institutional theoretical perspective, she particularly focuses on groundwater governance, community participation, self-organization, reflecting a deep understanding of the complexities and challenges within this crucial domain. Dr. Seemi Waheed is a public policy expert with over 32 years of service to the government of Pakistan. She specializes in civil service training reform and project coordination. She is also an active member of the International Association for the Studies of Commons and International Water Association. Dr. Seemi Waheed, if you could kindly come on stage and present on cooperation for sustainable water resource governance.
Sure, I thank the organizers for giving me this opportunity to share my work here. And I'm going to focus on most of the things have been said, but let's see what I can share with you. The core argument that I'm going to present here is that the water sector is a multi-actor and multi-organization and multi-interest phenomena, and it seeks cooperation and collaboration from all actors for its sustainability. This research which I'm going to present is for the safe supply of safe drinking water, particularly to the rural areas. And the source of this water is fresh water, and groundwater is a fresh water. So if you really look at how much is the fresh water available, it's only 3% of it, which is available to the whole world. And not necessarily that all groundwater is not drinkable water, because there are areas, depending on the rock formation and depending on the soil chemical compositions within that, the water composition, chemical composition changes, and it's not fit for human consumption. So there is very little fresh water which is available for human consumption, and that's the focus of the research. So for cooperation, I think one thing which is very important is to understand that human beings are responsible for the condition in which they are. And it's really the behavior of human beings which could either be very selfish or it could be altruistic, cooperative, helpful. And human beings are also very good at defying the laws, and they feel very proud when they defy the law in certain cultures. When they defy the law, they feel that they have more power, law or rules or regulations. So my perspective is that the perspective that I bring into my research is institutional perspective, and that's what the policy is. So all human beings behave in a very rational way, and as irrational beings, they are self-interested, and self-interest is always not very good to the common resources. So what do I have to say? We need to understand this behavior, and one of the ways that can modify human behavior is the policy. That is one of the functions of a policy, to modify human behavior, to maintain sustainability, and how do we formulate those policies which can sustain this resource, which is water we are talking about. And we are looking this from the common resource perspective. And common resources, yesterday a speaker gave a definition of the common resource. It's the same, but common resource is natural and it's man-made, and it has two characteristics, which is subtractability and excludability. And subtractability is that one person is using it, you lessen the benefit for the use of the other person. And water is one such thing. Excludability, you can't. The use of groundwater, you cannot exclude. Anybody can bore and can pull out water, despite the law that exists in Pakistan. So what does it require? It's a collective action situation, and we need to recognize that there is a conflict between individual interest and the common interest, that is the group interest, that the interest of all the people that are there. So, but I think the most important thing that we have been talking about, or whatever we talk in the context of water, whether it is law, it's legislation, or it's any policy, it has to be seen in the context of the social and political systems, which is really the venue of all these collective actions. And if that background we see, we will understand many things which relate to water in the context of Pakistan. So I always see this, that how do people see this resource? How is water? And that's exactly what when I was discussing it with people during my work, this is what I was asking them: what is this resource like for you? Do you think it's a limitless resource? It's an infinite resource? And I had this discussion with people right at the grassroots level. And I believe personally myself, then when you listen to the grasshoppers, really the people who matter, policies do not reflect the aspirations and the needs of the people who are at the grassroots level, but you need to listen to them. So I'm going to talk about it. What do they see? What is water like for them? But for cooperation and coordination, I think there are two things that, if we look at from the institutional perspective, is we need to understand the characteristic of common resource, that is water. What are the characteristics of that resource? And if there are a few characteristics I can mention. One is that that resource totally ruined? Is it totally destroyed? In the case of water in Pakistan, it is not, but it's quite at the verge of being, not destroying, but we are doing it every day, not very good to water in so many different ways. Is this resource predictable, that you're going to get it in future? This is another characteristic of a resource. So the characteristic of users, how much dependent they are on that resource, how much dependent. Is their livelihood dependent on this resource, and they're going to give importance to that? Do they have the autonomy, do they have the experience of self-organizing? Do they have the capacity to self-organize? Are they being trained to self-organize? Do they have the autonomy to formulate rules which are beneficial to the group? And of course, keeping in view the self-interest. Both these characteristics, which is the user's characteristics and the characteristics of the resource, they interact. So if people think that, in the case of Pakistan, if people think that it's a limitless resource, then how they are going to treat it? They are not going to treat it with care and prudence. And then there are other questions that arise. So I think that is how you can that's one way of achieving cooperation and coordination if that is incorporated in the policies. These are some of the pictures drawn from my work. This is the one, this is a rural water supply scheme. Again, a common resource, decrypt, dilapidated, and then this is an overhead water reservoir. This is a lake which supplies water to Pind Dadan Khan. It's called Swake Lake, and the bottom is, you can see the bottom of it, the water is so clear in this lake, and it supplies water to 1,000 households in Pind Dadan Khan. And of course, this is the Ruhi Nala, which also passes in front of the gate of, it's an 18-kilometer, it passes through different zones of Lahore. From where it originates, I have to see it, I see it by walking. I walk along this, and then I discovered this lake, that where it starts from and where it ends. I know I see the end. The end is, it falls in the Hadyara drain, and the Hadyara drain falls in the river Ravi. And river Ravi has turned into another sewage drain, I just would say, because it takes all the wastewater of Lahore. This is my ongoing work, and still not finished. I'm working on this. How did I do it? A bit about the methods, and I used 5 case studies in the rural areas of Punjab and surveyed some from the same case studies, 300 households. Had focus group discussions and interview of officials, 50, right from the top to the bottom, what we call as the street level bureaucracy. And then I took 2 policies I'm going to talk about. I did the text analysis of policies using institutional grammars. One was the Punjab Water Act 2019. Which is, in this academic and scholarly language, is called the collective choice level policy, which is a higher level policy, and which really affects the operational level policies, and operational level policies are those policies which really shape your day-to-day operations of the work. So the text analysis was done, and why was done? I was looking at how I use the word synchronicity, policy synchronicity, whether they synchronize or not. Selection criteria of the case studies was that they should be geographically dispersed within Punjab. They should be similar. They were similar cases of water supply and wastewater managed, collaboratively managed by the communities. These are selected in sweet water zones and the brackish water zones to understand that how do people behave. And then there are altogether, let me tell you, there are 3,400 rural water supply scheme in Punjab, and CBOs are constituted and trained in operations and management, maintaining their accounts and expenditure and other matters by the government. So they are self-organized, they have the capacity to self-organize. Of course, they have their challenges that I'm going to mention. What are their challenges in that? So these are the different policies. Some of them has been mentioned by the earlier speaker, but let me tell you that Punjab Water Act 2019, when you see a number into 2, that other provinces have also, KP usually follows Punjab, and they have also formulated their water policy. Other provinces have not. The national policies, drinking water policy, all the 4 provinces have their drinking water policies. Punjab has Punjab sanitation policy. Of course, Pakistan Environmental Protection Act. Then each province, since it's a provincial subject, each province has have their own respective environmental policy. And then there was the law which was called the Drainage Act, 1800 and something, that has been replaced by the Punjab Irrigation, Drainage and Rivers Act 2023 after the 2019 legislation, this law was passed at 23, and some of the aspects which are given, the sections also refer to the Punjab Water Act. On the right side, you see the different institutional arrangements, and at the provincial level, it's the this question is who is responsible for the groundwater. In Punjab, the responsibility for groundwater, because this Punjab Water Act it also gives it says that you have to create two authorities. One is Punjab Water Commission, which has already been created after a long dispute and debate amongst different who is going to be the chairman of the Punjab Water Commission, and the other is the Water Regulatory Authority. But Water Regulatory Authority has not been created. The law provides this provision that there should be a regulatory authority, but still, till as of today, there is no Water Regulatory Authority. The commission has been created, and the commission has a very kind of a broad function. It's really the regulatory authority which is responsible for regulating the water. So let's go to the findings. Some of this work is published, some of it is under review, some of it is in process. So I will just go to the findings, and if you have any questions, I'm ready to answer those questions. One of the things is that the institutional statements of the two policies show little coherence in the implementation approach. They have very diverse implementation approach. So I think we have talking a lot about it. It's been mentioned, is that there should be some synchronicity between the policies that we create. So the people at the grassroots level, those who are to implement those policies, they should know that there is some sense of alignment within the policies. So the government organizations and processes are fragmented. I think this word fragmented has been used before as well, and incapable of developing. I've used a stronger word, incapable of, let me be a little kinder to them and say they have less capacity to develop for realizing integrated water governance processes. The structures, hierarchical structures could be good, but they are not good for all, solving for all kinds of problems, so they need to look into it. There is a bureaucratic disconnect. What is bureaucratic disconnect? I have defined in my research, there is a disconnect within the organization. The top man of any department, I'm not saying all of them, but some of them, because since I worked in the government, for me it was easy to access them despite the fact that I knew people. I know how difficult it was to really, to get time from them and all that. But you find an odd person who really wants to bring change. But during the time that I was working in Public Health Engineering Department, with whom I was in constant touch, right from the secretary to the SDOs and the community development officers and all that, in 3 years, 5 secretaries were transferred. And that does create a serious governance problem. There are people who are interested in implementing the policies, but there are people who are disinterested. And one of the secretaries was saying this Public Health Engineering Department is an orphaned department because anybody who doesn't find a place in the government is posted there. For the big cities, let me say, they are VASAs. Lahore's water and sanitation is managed by VASA. But other cities, they are water supply and the sanitation responsibilities of Public Health Engineering Department. So it's a very important department if you think in terms of water and sanitation. Most policy documents are donor driven. I have almost seen all the. I've seen majority, largely. I've read them and I found then that what is written by the donors' documents, the grey literature, and the other literature by the government, documents of the government. And these, since they are donor driven, because they give money, so there is less ownership of these documents and so of the policies, particularly the collaborative policy that the rural water supply systems would be managed by community-based organizations. Now we come to the community-based organizations. Is self-organizing capacity and institutional compliance to maintain drinking water resources increases. The community-based organizations which were able to collect resources, and I'm going to talk about it, is the water rates that they have. They are able to maintain the rural water supply system. Where the support from the government, which is usually less from the government, relational factors improved institutional compliance. It is amongst the community. They raise their own resources. How do they raise their money? Is largely philanthropy. When they see the work of the rural water supply, there are donors and they help the community-based organizations. So it's the trust, commitment, communication, and transparency are important drivers for philanthropy and cooperation. So trust is the most important matter when it comes to cooperation and collaboration. And that's the question. It's it's easier to say to build the trust, but it's very easy to break your trust. And once you break your trust, it takes a much longer time to build it, and particularly between the government and the citizens. No wonder there is ethnicity and politics and have significant effects. And what does it affect? Those who do not pay for their water bills, the community-based organizations cannot force them to pay their bills. And it's usually the ethnicity, their personal relationship, the biradris and all that, they come into play. I talked about the shared meaning. How do people see this resource? It is seen as nature's gift, which is never going to end. And this is a large majority of people in the rural areas. And I was thinking, why is it so? I think people living for centuries on the bank of rivers, they have all, particularly in Punjab, they have always seen the river flowing. And they have always, these rural water supply schemes came very late. Usually in traditional sense, people had hand pumps, or they pulled water from the well or the river or the canal. They were not that polluted at that time. So it is a nature's, and then because of that, because it's a nature's gift, there is a remorseless, unabated groundwater abstraction in areas, particularly which is sweet water zone. You have a rural water supply scheme, and this example of Kasur, at once there was, except when the tanneries came in and the water of Kasur was polluted and became unfit for human consumption, only then they started, introducing this rural water supply. But the area has a sweet water. And what is the result? People did not, connect themselves with the rural water supply scheme, and they started digging their bore. And each house is its own bore. Imagine, if you pull out that amount of water, what's going to happen to that water? No sanctions on groundwater abstraction. No sanctions. It's anybody can do. It's same as in Lahore. Water users are willing to pay the bill. Let me tell you, I conducted a survey, and within Lahore, 70% of the people who were surveyed, they said, yes, we are ready to pay the water bills, but the flat rates are very unfair. Vasa has flat rates, and so has all these rural water supply. So flat rates, they say, and there was a person, a rural person, he was saying, a villager who said, I have a small family, and the other person has got 10 members in his family. I'm paying the same rate and he's paying the same rate. Very logical, reasonable, sounds, it's unfair. So people should, and people are ready to pay that their water meters should be, the water bills should be consumption based. No water metering, wastewater. And that's a very important part of it. Wastewater, in whole of Pakistan, there is no wastewater treatment plant. all water in rural areas, they go in open spaces, and it can go anywhere. Water quality is an issue despite institutions. There is a requirement that water should be tested every month, and Public Health Engineering Department has got at the district level water testing labs. And the way the water is tested and the way they collect samples of water, which is very unscientific. I've seen that. And they test it and they say it's fit for human consumption. I took the water sample and I got them tested from PCSIR, and none of the water, it was good. The chemical composition was acceptable according to the World Health Organization. But the microbial contamination, my gosh, every water sample had microbial E. coli. It was extremely high. So even if you have, and this was one, I took the samples from the rural water supply from the source, and I took it from somebody's house, and so I could see it was higher when it was taken from somebody's house. So no water, tap water. And let me also say, we trust the water companies. I'm going to get it tested one day, I do not know. According to PCWRC, they tested the water samples of the water companies, and they were also not fit for human consumption. So I end by saying that there are multiple organizations and policies, but almost no coordination, monitoring, enforcement is the weakest area. I haven't seen any institutional arrangements for enforcement. Even if they are, people would not want to enforce, would not like to fine, would not like to, just cut the connection. You will have this, you'll request somebody, and your service will be reinstated. So we have to see all this in the social and political venue in which all this is being done. As a multi-actor, multi-organization, multi-interest matter that requires collaborative approach, it does require collaborative approach because it's configural. Everything is interconnected, it's nested, but each works in their own silos. Suggestion is easier said than done. It's the most difficult task to engage the users at various stages of planning and execution, because that requires a lot of hard work that would increase the quantum of work of those who are working in public sector organization. Water metering and pricing need to be rationalized to sustain the available water resource. I have not talked about the wastewater management. That's another area that requires attention. Thank you very much.